Interstate Relations. So, introduction. The Constitution makes the following provisions with regard to the interstate committee. Adjudication of the interstate water disputes. So, interstate water disputes is Article 260. Coordination through the interstate councils. We have the interstate water disputes, and then we also have the interstate councils as well. Mutual recognition of the public acts. If there is a public act, both the states must recognize, or the states involved must recognize mutually. Mutual recognition of the public acts, records, and the judicial proceedings as well. Freedom of the interstate trade, commerce, and intercourse, but the interstate trade, commerce, and the intercourse. Interstate, when there is an interstate trade, commerce, they are controlled by the central government. The central government makes laws for these areas. Zonal councils were established by the parliament to promote the interstate cooperation and coordination. We have 5 zonal councils. They are from the 7th Constitutional Amendment Act of 1956, States Reorganization Act. Interstate water disputes, Article 262 of the Constitution provides for the adjudication of the interstate water disputes. For the interstate water disputes, we are having an article, right? Article 262 is the adjudication of the interstate water disputes. Parliament by law. Here, the Parliament needs to make a law for the adjudication of the dispute with respect to the use, distribution, and control of the waters of the interstate river or the valley. The Parliament is the one which is going to make laws. Parliament is going to make laws. The Parliament, with respect to the distribution, this is with respect to the distribution, control, and use, distribution, and control. The Parliament may by law provide for the adjudication of any dispute with respect to the use. We are going to have the use, distribution, and then we are going to control of the waters of interstate river and the river valleys. Parliament may also provide that neither the Supreme Court nor any other court is to exercise jurisdiction in respect of any such dispute or the complaint. It can also provide that any other court or jurisdiction with respect to that dispute. Under Article 262, the Parliament has enacted 2 laws. We have the River Boards Act of 1956 and the Interstate Water Disputes Act of 1956. So we'll be having the River Board. That is going to be the River Board Act of 1956. The River Board, right? And Interstate Water Disputes Act of 1956. The provisions for the establishment of the river board for the regulation and development of the interstate river and river valleys. For the regulation, this is interstate river and river valleys. Central government can establish the river board on the request of the state concerned and interstate water regulation. Empower the central government to set up an ad hoc tribunal. To this, there is going to be a tribunal. Ad hoc tribunal. Right. But the River Board Act of 1956, through this they are going to have a river board for the maintenance of the river valleys. But here we'll be having a tribunal, that is a like court, right? We'll be having a court with the help of the interstate water disputes. Interstate water disputes is going to provide us with a court, whereas we have the River Boards Act of 1956. Provides for the establishment of the river boards for the regulation and the development of the interstate river and the river valleys. Interstate Water Disputes Act of 1956, the River Boards Act and the Water Disputes Act of the same year, 1956. It empowers the central government, is present right, to set up the ad hoc tribunal. There is a tribunal over here from the central government for the adjudication of the disputes between 2 or more states in relation to the waters of the interstate river or the river valley. Tribunal must give its decision within 3 years and it may be extended by 2 years. So the tribunal, there is a time limit for giving the verdict. Tribunal must give the verdict within 2 years, or there is again an within 3 years, or there is an extension of 2 years. Within 3 years, may be extended by 2 years. So total we have the time limit is 5 years to give a verdict. The decision is binding, final, and the decision has the same infringement as that of the Supreme Court. Now there is an amendment for this 1956 Act. First we be having the River Board Act of 1956, where there is a bill to govern or to regulate the interstate river and river valleys. Whereas for disputes, there is the need to set up the tribunal, which must give its verdict within 3 years, may be extended to 2 years. This tribunal is by the Interstate Water Disputes Act of 1956. Next, we have the Interstate Water Disputes Amendment Bill of 2019. There was an amendment bill, right? For this amendment bill, when the state puts a request regarding the avoiding water dispute, the central government will set up the disputes resolution committee. We have the states, right? The states is going to put the request regarding the water dispute. When there is a water dispute, the state government is the one which is going to put the request regarding the water dispute. The state government is the one, right, which is going to put a request initially for resolving a resolution committee is being formed. This is going to resolve the through the negotiations. Resolve dispute through the negotiations within 1 year, which is extendable by 6 months. Within 1 year, first let us resolve. Instead of going to the tribunal, first let us resolve, right? For resolving, we have the states must request. The states is going to request, and when the states are going to request, we are going to have a dispute. We say these are the disputes, right? Disputes resolution committee. Disputes resolution committee. So we'll be having the disputes resolution committee. This belongs or this is under the Interstate Water Disputes Act of 1957. The same Act, Interstate Water Disputes Act of 1957. When the state is going to put a request on the behalf of the state regarding the water dispute, the center will first set up a dispute resolution committee to resolve negotiations through the negotiations within 1 year, or which is extendable by 6 months, and submit the report to the central government. If a dispute cannot be settled by the DRC, is nothing but the Dispute Resolution Committee. The central government will refer the matter to the Interstate Water Disputes Tribunal. Such referral must be made within 3 months from the report of the Dispute Resolution Committee. Right, 3 months and 1 year, which is extendable to 6 months, and referral to be made within 3 months from the receipt of the report from the Dispute Resolution Committee. Now, tribunal must give its decision within 2 years, extendable by another year. So that date has also been reduced for the tribunal. 2 years extendable to another year. Decision of the bench will be final and binding. Now we have to, instead of knowing when they have formed, we have to go for the tribunal and the states involved. Right. Krishna Water River disputes. When it is equal to the Krishna water, you have to go for the Andhra Pradesh and Telangana, Maharashtra, Karnataka. For Mahanadi, we are going for Odisha and nearby Chhattisgarh. Odisha and then Chhattisgarh. Maharashtra, Karnataka, Andhra Pradesh, Telangana. Maybe Andhra Pradesh, Telangana. Maharashtra, Karnataka, Andhra Pradesh, Telangana. The dispute is related to the Krishna River. We know Mahanadi River, right? So Odisha and then we have the Chhattisgarh is for the Mahanadi River. Mahadayi River is in the Goa. Karnataka, Maharashtra is where we have Mahadayi River. Karnataka, Maharashtra, Karnataka, Goa. So Maharashtra, Karnataka, and then we have the Goa. Ravi and Bias is Punjab, Haryana, Rajasthan. Mansadara water dispute is between Odisha and Andhra Pradesh. In this, we will be having the Andhra, right? Andhra Pradesh and Odisha. Ravi and Vyas is Punjab, Haryana, and Rajasthan. Mahadayi is going to be, we have to remember Goa for Mahadayi. And Maharashtra and Karnataka. Mahanadi is for the Odisha and Chhattisgarh. Krishna is Maharashtra, Karnataka, Andhra Pradesh, Telangana. The next one is related to the interstate councils. Interstate councils. Now, the interstate councils belong to Article 262. Article 262 is related to the interstate water disputes. But interstate means a councils, right? The president is going to establish such a council if for any time it appears that public interest will be served by its establishment. Now, when we see Article 62, water related to rivers, it is established by the Parliament. When it is river, it is established by the Parliament or the central. Whereas we are seeing uh, central government to set up the dispute. Central government, right? Over here, Parliament has enacted laws where the central government is establishing the uh, interstate tribunal, whereas we are going here with the president. President for the interstate councils, we are going for the president. Specifies the duties that can be assigned or going in the following manner: inquiring into and advising upon the disputes which may arise between the states. If there is any dispute between the states, we are going for the interstate councils. Investigate subjects in which the states or the centers and the states have common interest. Make recommendations upon any subject and particularly about better coordination of policy and action on it. Now we have to make recommendations upon any subject, right? There is recommendations particularly for the better coordination of the policy and action on it. Establishment of the Interstate Council. We have Interstate Council. The Sarkaria Commission on the Interstate Relations strongly recommended the establishment of the permanent Interstate Council. Under Article 63, we will be having the Sarkaria Commission and the establishment of the Sarkaria Commission on Interstate Relations. We have Sarkaria Commission, right? This Sarkaria Commission recommended the establishment of a permanent interstate council under Article 63 of the Constitution, which consists of, when we are having a permanent interstate council, it must consist of the Prime Minister as a chairman, right? When Prime Minister is included, he automatically takes the rest of the chairmanship and chief ministers of the state. So the CMs are also being participated, the chief ministers of Union territories, which have legislative assemblies, and administrators of the Union territories not having the legislative assemblies. If there is no legislative assemblies, we are calling those administrators. Governors of the state under the president's rule. 6 cabinet ministers, including the home minister, to be nominated by the president. The council is a recommendatory body, and the council must meet at least thrice in a year. Since its first meeting in 1990, it made 2011 times. All the questions are decided by the council, and it is assisted by the Interstate Council Secretariat. We know all the prime minister, CM, and then we have administrators, right? Administrators and governors if there is a president, administrator and governor if there is a president. Governor if there is a president. And we have 6 central cabinet ministers. The cabinet ministers are 16 members. And there are 6 central cabinet ministers. The cabinet ministers, which includes the home ministers, including the home minister. Right. To be nominated, these are nominated by the Prime Minister. This council is a recommendatory body and the council meets at least thrice in a year, but since its first meeting it has met only 11 times. Now we say that the Sarkaria function for the center-state relations. One thing we have to keep in our mind is this. Sarkaria function is for the center-state relations. It recommended the establishment of permanent interstate council. It asks for a permanent interstate council. Now we have article for this permanent interstate council. It's Article 63 of the Constitution. That it consists of the Prime Minister and then Chief Ministers, administrators, the governor, if there is a President's rule, and central cabinet ministers, 6 in number. This includes 4 ministers. They are recommended by the Prime Minister, nominated. Now, all the questions are decided by the consensus and it is assisted by the Interstate Council Secretariat. We have public acts, records, and judicial proceedings, right? The jurisdiction of each state is confined to its own territories. When we have a state, it is having its jurisdiction confined to its territory alone. This act of one state may not be recognized in the act. To avoid confusion, the Constitution has full faith and credit clause. Article 261. So this is important. Article 261, 262, 263. Article 262, 263 is related to the states, right? Therefore, here also full faith and credit clause. You are having faith and then there is also a credit clause in Article 261. Full faith and credit is to be given throughout the territory of India to the public acts, records, and the judicial proceedings to the center and every state. I have full faith and I give full credit to the acts which is made throughout the India. This is applicable. The faith clause is applicable throughout the India. Article 261 deals about the full faith and credit clause. Full faith and credit is to be given throughout the territory of the India. It is throughout the territory of the India to public acts, records, and the judicial proceedings of the center and the every state. Public act includes both the legislative and executive acts of the government, and public record includes any official register or the record made by the central public servant in discharge of his duty. We have public act as the legislative or the executive acts. And what is a public record? It's the official book. We are having a book. This book is a register which is made by a public servant. The manner in which the conditions under such acts, records, and proceedings are to be proved and their effect determined would be as provided by the laws of the Parliament. Final judgments on orders of the civil court in any part of the India are applicable or capable of execution anywhere in India without the necessity of reference to the judgment. When we are having the order of a civil court, it is applicable throughout the India, right? In interstate relations, we have the trade and the commerce. When we are speaking about the interstate trade and commerce, we include this in part 3 of the Constitution. When we are included this in the part 3 of the Constitution, the articles are Article 301 to Article 307. 1 to 7 is related to the interstate trade, and then we have the commerce. This is very important, and mostly the interstate trade and commerce is governed by the central government. The trade between the states and the commerce between the states. Now, Article 301 declares that trade, commerce, and intercourse throughout India shall be free. First is it is free, right? And it is not confined to the interstate trade, commerce, and intercourse, but also it extends to the intrastate trade, commerce, and intercourse. Defines this. What does Article 301 do? It declares that the trade, commerce, and the intercourse throughout the India. When there is a trade throughout the India, it is going to happen freely. We have a united tax, a single tax throughout the country. So there is going to be trade within India, right? Therefore, it is free. We are not having any customs duty. for those trade. Article 301, freedom from all the restrictions. The trade is also not having any restrictions except those provided under other provisions. Now we have Article 302 to 305 in Part 3 of the Constitution. Part 13 of the Constitution. This is restrictions. Restrictions are placed in this itself. These are explained as the power of the Parliament to impose restrictions on the trade, commerce, and intercourse between the states or within the state in public interest. The Parliament is imposing restrictions. For example, there is restrictions on the liquor sale, liquor trade, and alcohol like cigarettes. If there is a restrictions, it is for a public interest. Legislature of the states can impose reasonable restrictions on the freedom of the trade, commerce, and intercourse within the state or within the state in public interest. But a bill for this purpose can be introduced in the legislature only with the previous sanction of the president. Now, what are they trying to say? The first thing we have understood is that the Parliament is imposing reasonable restrictions under the public interest. Now we have seen that Article 302 to Article 305 are reasonable restrictions to the interstate trade. There are the reasonable restrictions to the interstate trade. Now the first point is that the Parliament is going to impose restrictions on the trade, commerce, and intercourse between the states and within the state in the public interest. Legislature of the states can impose the reasonable restrictions on the freedom of the trade, commerce, and intercourse within that state or within the state in the public interest. Right? Even the legislatures can impose restrictions. But when the legislature is imposing the restrictions, it needs to get the sanction of the president because it is an interstate is involved over here with that state or within that state in public interest. Now, Parliament can put reasonable restrictions in the interstate trade. Legislatures of the state can also put when they have sanction of the president clearly. State legislatures can impose on goods imported from other states or union territories any tax which is similar to goods manufactured in that state are subject. A parliament of the state legislature can make laws for carrying the trade, business, industry, or service, whether to the exclusion, complete or partial, of the citizens or otherwise. Now, there is a tax, when manufacture tax, which is similar to the manufacture tax. If something is being manufactured in the state, we are going to put tax rate, production tax. For manufacturing, we are going to give the production tax. Now, this production tax can be imposed on the goods which are imported from other states as well. The state legislature can impose this production tax if the same thing is being produced in its own territory on the imported goods. The parliament or the state legislature can make laws for carrying on trade, business, or industry or service, whether to exclusion, complete or partial, or citizens or otherwise. Now we have zonal councils, right? They are established under the State Reorganization Act. Initially 5 zonal councils: North, South, Central, West, East. We have Northeast as well. Northeast has been created later. Northeast Council has been created in 1971. The zonal councils are statutory and they are not constitutional bodies. We have a States Reorganization Act of 1956. From this act, the Parliament has established the zonal councils. There are 5 zonal councils: North, South, East, West, Central, for each zone. Totally there are 6. Later in 1971, we were having the Northeast Council. Factors of consideration while forming the zones: the natural divisions of the country, the river systems and the means of communication, the cultural and linguistic affinities, requirement of economic development, security, law and order. Who are the members? Home Minister will be there. Chief Minister will be there. Home Minister is the chairperson, Chief Ministers. And ministers, 2 ministers from the state, administrator of the Union Territory in the zone. Right. We have Home Minister for the zonal councils. We are not having Prime Ministers. So this is the important point which we have to note. There is Home Minister, but there is not Prime Minister. Right. Home Minister of the central government and Chief Ministers, and then we also have other ministers as well. Chief Ministers and other ministers from each state, administrator of each union territory, advisors of the zonal councils without the right to vote. There is also advisors, persons who are advising. Advisors are having no right to vote. A person nominated by the Niti Aayog. Now we will be having Niti Aayog. Chief secretaries of each state will be joining and the development commissioner of each state. Home Minister of the central government is the common chairman of 5 zonal councils. Each minister acts as a vice chairman of the council by rotation, holding the office of a period of 1 year. So, for vice chairman, the post is having a rotation. Home Minister is the chairperson, common chairperson of the 5 zonal councils, but the Chief Minister, for rotation, he is going to hold as vice chairperson in 1 year. Northeastern Council, right? Northeastern Council was created by separate legislation, is called as Northeastern Council Act of 1971. Members is going to be, we know that we have Assam, Arunachal Pradesh, Meghalaya. Assam, Arunachal Pradesh, Meghalaya, right? Manipur, Mizoram, Tripura, Manipur, Mizoram, Tripura, here we have Sikkim, right? So, totally we'll be having 8. Assam, Arunachal Pradesh, Meghalaya, Nagaland, Manipur, Mizoram, Tripura, plus Sikkim, right? The first is we'll be having Assam, then Arunachal Pradesh, Meghalaya, Nagaland, Manipur, Mizoram, and parallelly here we'll be having Tripura. That's it. This is how we'll be having Tripura, and here we have the Sikkim. Few additional functions is to formulate a unified and coordinated regional plan severing matters of common importance. Review periodically the measures taken by the member states for maintenance of the security and public order. The members of the Northern Zonal Councils is Jammu and Kashmir, Himachal Pradesh, Haryana, Punjab, Haryana, Himachal Pradesh, Delhi, Chandigarh. But we have the Central Zonal Councils is where we have Uttar Pradesh, Uttarakhand, Chhattisgarh, Madhya Pradesh. In the Eastern Zonal Councils, we have Bihar, Jharkhand, West Bengal, Odisha. Western is Gujarat, Maharashtra, Goa, Dadra and Nagar Haveli, Daman and Diu. Southern Andhra Pradesh, Telangana, Karnataka, Tamil Nadu, Puducherry.